All right, let's go ahead and start our second session, our leave and accommodation update. Again, one of the common questions that we get on a day in, day out basis is just kind of help us deal with the employees for good or ill who need accommodations, or at least asking for them, who need leave. We have, as I said, some legislative developments to share with you as well, some uncertainty surrounding those, things to develop through the rulemaking process and otherwise, but we'll start to preview some of those changes, particularly in Minnesota, and review all of the other developments, case law and otherwise. So with that, panel, take it away.
Thanks, Ryan. Hi, everybody. I'm Rebecca Bernhard. I'm a partner in our labor employment group, and I am extremely excited to see so many people in 3 dimensions. I'm one of the rare extroverted attorneys, so this is just really exciting. So exciting. With me are Anabel, Cassady, and Jillian Kornblatt, and I'll let them introduce themselves when they get to their part. But really quickly, assuming I can work this. There we go. This is our agenda, as Ryan said. We're going to talk about all of the legislative activity in Minnesota, but also how it implicates federal law that might have been happening at the same time. And we'll talk about some other states that Minnesota's kind of following in their footsteps, similar to the non-compete discussion that we just had. So we're going to start with sick and safe leave on a statewide level. We'll go into the paid family medical leave. We've got expanded pregnancy and pregnancy-related protections. Rough versus DeJoy is a federal Supreme Court case that recently came out. So that's where we get into the federal stuff. And then we're going to have a panel discussion because a lot of this stuff is new. So we don't have as much case law and guidance on it yet. So we're going to do a little mini prediction and hopefully helpful tips on what we understand. So I think Anabel's going to start us.
That sounds great. Thank you, Rebecca. I'm Anabel. I'm an associate in Dorsey's Minneapolis office in the labor and employment practice group, and I'm also really excited to see so many faces, some familiar and some new. So thanks for coming and welcome. So with regard to statewide sick and safe leave, as we all know, there's no federal paid sick leave law. But in the absence of a federal policy, we're seeing more and more states passing paid sick and safe time leave laws, as well as statewide paid family and medical leave laws, which Rebecca will discuss momentarily. So currently 15 states plus DC have paid sick leave laws. So we've got Arizona, California, Colorado, Connecticut, DC, Maryland, Massachusetts, Michigan, Minnesota, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, and Washington. So the list is growing. In addition to statewide paid sick leave laws, we've also got 17 cities and 4 counties that have passed such laws. So for instance, in Minnesota, the cities of Minneapolis, St. Paul, Duluth, and most recently Bloomington have paid sick and safe time laws.
That's laugh worthy.
So generally, sick and safe time is paid time off that employees can use when they or their relative is sick, injured, or receiving medical treatment, including mental health and preventative care. It can also be used to cover absences or when employees need to care for themselves because they are a victim of sexual or domestic violence, such as needing to go seek a restraining order or relocate to safety. And it's also paid time that employees can use when their workplace or their child's daycare or school is closed for certain reasons, such as, due to weather or a declared public health emergency. Minnesota's paid sick and safe time law goes into effect this coming January 1st. The law will not preempt other local paid sick and safe time laws in Minnesota. So employers will want to follow whichever law is most protective of employees. The law has a pretty expansive scope. So for instance, it covers all employers with 1 or more employees. And unlike some laws, there is no small employer exemption. all employees who work at least 80 hours in a year for an employer in Minnesota, including temporary and part-time employees, are covered by the law. Employees will accrue 1 hour of sick and safe time leave for every 30 hours worked. And they begin accruing the leave when they start employment. So for purposes of accruing sick and safe time leave, exempt employees whose normal work week is 40 hours are deemed to work 40 hours in each work week. Employers can limit accrual to 48 hours per year. And in terms of carryover, employees may carry over unused sick and safe leave from year to year, but employers may cap it at 80 hours. In lieu of carryover, employers may front load instead. So they can front load 48 hours of sick and safe leave to all employees. The leave will be available to employees as soon as it's earned. So eligible employees can use that statewide sick and safe leave for a number of reasons, similar to the reasons that I listed earlier. Specifically, they can use it for the employees or a family member's mental or physical illness, treatment, or preventative care. They can use it for an absence due to domestic abuse, sexual assault, or stalking of them or a family member. They can use it for the closure of the employee's workplace or a family member's school or care facility when closure is due to weather or public emergency, and then also for absences caused by circumstances analogous to the COVID pandemic. I do want to highlight that the definition of a family member under Minnesota's law is really extensive. So I won't list all of the individuals that fall under the definition, but just to flag, it includes foster children, legal wards, step siblings, foster siblings, foster parents, stepchildren, step parents, step grandparents. The list kind of goes on, and notably, it also includes individuals related by blood or whose close association with the employee is equivalent to a family relationship. And it also includes up to one individual annually designated by the employee. So there are a few things that employers should consider doing in anticipation of the upcoming January 1st effective date. First, employers will want to update their handbook policies with information on sick and safe time leave. In particular, employers will want to make sure that their handbook includes notice of employees' rights and remedies under the law. Second, they'll want to make sure to update their HR processes. So the law requires that earnings statements include the total number of sick and safe time hours accrued and the total number of hours used during the pay period. And by January 1st, or the start of an employee's employment, whichever is later, employers must give notice to all employees regarding their rights under the sick and safe time law. And the information must be included in English as well as the employee's primary language. A uniform notice prepared by the Minnesota Department of Labor and Industry is expected to be available by January 1st of 2024.
Okay, maps. Hopefully people can see that. I'm going to move into state paid family and medical leave, and mostly going to focus on Minnesota's new law and what we know so far and what we don't know. But before we did that, I wanted to kind of give you this lovely map. So the red is or at least it's red on mine. So the vast majority of states don't have a paid family leave. States with a paid family leave program that's just about to be implemented or it acted like Minnesota's but not yet implemented would be the blue, and then the pink are states that have active leave. So many of our clients who have a presence all across the country are already dealing with something comparable to Minnesota's imminent paid family medical leave or are about to deal with it. Some of the states that that we're familiar with, of course, are California and New York and Colorado, Oregon's. Some of it, the work started at the beginning of this year in terms of payroll deductions and things like that. Employees can start taking leave in September of this year. Texas has one that's implemented, but we're not sure how that's going to manifest. There are differences. Most of the states that either have it or are contemplating it, and this includes Minnesota. And again, I'll go into detail in a minute, but it's generally a payroll contribution, much like unemployment. And so many of the states that already have it are actually using that same state agency to enforce it. So I see my lovely colleague Melanie in California, who's woefully familiar with this, nodding vigorously. So I'm on the right track. So that's good. But like in California, you apply at the unemployment department, and basically you either say, I've been laid off of work, and you get in the unemployment line, or I'm ill and can't work, and you get in the family medical leave line. And so I'm hoping that that's the way Minnesota works, and that's the kind of evidence. And I should actually give a shout out to Molly Siegel, our colleague, because she actually knows this stuff and really helped us prepare. And so I'm going to be using her list when I start going into details in Minnesota in a second. But some places like New York, and so if our colleague Laura's on the line, thanks. It's a private insurance. So you have to actually get insurance to fund the New York's benefit. So there are some differences across the country. And when we do our discussion after our formal presentation, we'll talk about how are people complying with this patchwork of laws.
The easy part we saved to last. Right?
Yes, exactly. Yes, that way if we run out of time,
Deal with it. No.
Exactly. My secrets have been exposed. Okay, so let's start with the good news. The benefits actually don't begin until January 1st, 2026 in Minnesota. Okay, so everybody take a deep sigh. So that means we actually have 2 years plus to really start getting ready. Now, there's a whole schedule of dates that the government has to follow to get there. And so there's a lot of stuff that all the various agencies that are going to be handling this new benefit are going to start doing before January 1, 2026. But generally, the employers need to think about that as the sort of date when employees can start requesting the leave and getting the benefits. It's important also to note that it's, again, the proposed way that Minnesota is dealing with it is to basically have a state-run program, and that the contributions will come from a payroll tax, much the way unemployment tax works now. And there are some limits up there with regard to what the employee tax will be. Generally, an employee has to have more than $3,500 in wages over a period of a year to be eligible to receive that. And that's consistent currently with Minnesota's unemployment scheme. You have to have worked a minimum number to be eligible for unemployment benefits. So that's the way it's going to work from the employee side. Let's dig into what it's going to be doing from the employer's perspective for vis-a-vis what the benefits are for employees. And you're going to start to see some overlap with what Anabel just said and with what Jillian's going to say, because what we have is a couple different laws that are basically trying to protect people when they can't work for a variety of reasons. And the beauty for all of us employment lawyers who want full-time employment is that none of the definitions are exactly the same. So we get to sort of keep sorting this out, but there is a lot of overlap. So there's a family medical leave for Minnesota is sort of like unpaid federal family medical leave with some key differences. So for example, under Minnesota's program, the person has to be incapacitated for 7 or more days. Now, of course, under FMLA, which is unpaid, federal FMLA, it's only 3 days. Right. But if you think about it, Anabel just told you that you're going to be giving people sick time, right? All Minnesota employers are going to give people paid sick time. So This is designed to help be that social safety net when that paid sick time runs out, right? There's not double dipping here, right? We're not like, someone's not gonna get paid 3 times because they work in Bloomington, which is in Minnesota, and they qualify for paid family medical leave, right? They're not gonna get 3 days of pay for 1 day off, right? So that's how these are supposed to work, at least. And that we're gonna let, hopefully, the government figure that out for us, but, and give us good regulations. They've also broadly defined who, is, in the family. It's a little broader than the FMLA, if you're thinking about this as a state version of FMLA, but it's more akin to the family definition under the Minnesota paid sick leave, right? It's this broad definition. Another, catch-all under this law, which doesn't exist for obvious reasons, is the caregiver aspect, right? It's family and medical leave. So it's whether you need the leave because you are ill, right? So it's sort of tracking FMLA, but then it's also, you might have to give care to somebody else. So that part's got a really broad catch-all. I'm just going to read it. An individual who has a relationship with the applicant that creates the expectation and reliance that the applicant care for the individual, whether or not the applicant and individual live together. So I have a lovely neighbor 2 doors down. She might need care someday. And do I get to get paid family medical leave under the Minnesota law? So we'll save that for the panel. But she doesn't live with me, but I'm her friend and I'm going to take care of her. So that's pretty broad. There's a safety leave component, like with sick and safety leave. There is a sort of kind of up to 12 weeks for a single qualifying event, and then up to 20 weeks of combined if there's more than one qualifying event. That's a little different than the FMLA, but there's still an ultimate cap on that. Okay, so what should you do? So you should, of course, monitor the MDs, which is the department that's going to ultimately oversee this. We are monitoring MD because that complicated timeline that I'm not going to bother you with, they have lots of milestones between now and January 1st, 2026, where they're going to release guidance for everybody so that we understand how we actually are going to implement it. I should note that there is an option for an employer to apply to be exempt and say they have their own program that complies. And we do have clients who have done that in other states. We have clients who thought that they would do that in other states and then went into the process and decided 0.007% tax is less money than paying Dorsey and my own HR team to try to get out of this. We're just going to move forward. So, these are things we'll talk about during the panel as well. But you are going to have to start submitting a quarterly wage detail report, which we anticipate will be just more in line with the quarterly wage detail report that you're already providing vis-a-vis your unemployment compensation reporting, right? So we think it might be another form, but it's probably going to be along those lines. We don't know yet, but that's what we're assuming. And then they're going to, of course, have lots of posters and notices because this also has a posting and notice component to it as well.
Hi, I'm Jillian Kornblatt. Shockingly, I'm a partner in the Minneapolis Labor and Employment Group. So we're going to talk now about some specific aspects of the leave and some accommodations for pregnant employees. So we've got federal action and state action. So we're going to start with the federal, and this one has been in place not long, since June 27th. So it's the EEOC on their website is saying, so they're considering violations that occurred after June 27th. So you don't have to worry about that going back too far retroactively. They're also accepting charges starting that day. So, so it expands protections for pregnant and nursing workers. And the main thing it does is, it used to be that pregnancy wasn't treated as a disability, but if there was a disability caused by pregnancy, that disability had to be accommodated. Those of us who've been pregnant or thought about what it's like to be pregnant think it makes sense to just ditch that. If you're pregnant, you need some accommodation. So they're going to what are a lot of common sense, I would describe them, accommodations that should be granted. Things like opportunities to sit down, drink water, Appropriately sized uniforms, additional breaks for the bathroom, excuse for more strenuous activities, and unsafe chemicals. So, you know, kind of, again, common sense, but now they're part of the law. And, you know, I got an inquiry from a client a couple weeks ago who'd heard, you know, through the internet grapevine or whatever, that the standards were even more stringent than the ADA, but they're not. So it says that it uses the same definition of reasonable accommodation and undue hardship as in the ADA. So you don't have to reinvent the wheel there. You just think of it the same way. It's just adding one more category into those who may need accommodations.
Do you think, I'm going to interrupt you.
Sure.
That's a question. Do you think that they think the standard is different because what's changed is that you don't need that doctor's note that says I need more water? Right? I feel like that's a common thing that I'm hearing from clients too. The accommodation analysis isn't more strict, but you really have to take the pregnant worker at face value. It seems to me that's the part that seems more.
Yes, I agree with that. I think another part that stood out is this explicitly says you can't require the employee to take leave if another reasonable accommodation is available. But that's true under the ADA. I just don't think it got as much publicity. So I think that's part of where this started. Yeah. And, you know, pregnancies are common in the workplace, so it comes up, not that disabilities aren't. Okay, so moving along after the pregnancy. So we've got protections for nursing employees. So the Pump Act, this has been in place a little longer, since April. This further amends the FLSA that already provided some protections to nursing mothers. So this does a few things. It gives more requirements on what breaks the employee needs. And it really puts that more in hands of the control of the nursing employee to say what break time they need. It has to be granted up to a year after the child's birth. If the pumping time is less than 20 minutes, it has to be paid, just like any other break under the FLSA. So I think that will be potentially a switch to how employers are used to thinking about this. It gives some detail, and it's listed on the slide. I'm not going to read it, about what space to pump must be available. Not a bathroom. It's always put in there. It seems obvious, but you know, anyone who's pumped in a bathroom knows not ideal. So those are ones to consider. And remote workers are entitled to the same breaks and everything else as if they're working on site. I'm going to say this is one area remote employers are much easier, right? Go pump wherever you want. So there's one there. So that makes that easy. Everything else is hard, but we have that. So moving along, more expanded protections. So in Minnesota, this is part of the batch of laws, went into effect July 1. Pregnancy accommodations. So very similar in many ways to the federal protections. You don't need to have a disability. It is enough to be pregnant. It applies to employers of all sizes. Things like longer restroom breaks if needed, not just more frequent ones. Other things not listed on the slide are transfer to a less strenuous or hazardous position. Could be a reasonable accommodation. Job assignment modifications, schedule modifications. A bigger change, I think, is no longer limited to the 12 months after the child is born. So this continues at the discretion of the parent. So they can continue doing that. This has to be in the employee handbook, given to employees upon request, and the handbook also has to include the rights and remedies. So you can tick this off as another one of your handbook updates that you're going to need to make if you haven't already made it. And so moving on, more pregnancy and parental leave in Minnesota. So the Minnesota parental leave is in some ways a game changer that's fairly big, I think, because this now applies to all employers regardless of size and all employees regardless of how long they've been employed. So now if you have a new employee, they've been working there 3 months, they have a child, placed with them, they are now eligible for these same 12 weeks. So I was thinking about it, you know, good thing, challenging thing. So good thing is that in a tight labor market, maybe an employee who's about to have a child wouldn't be sticking at their old job just because they want to stick around for their FMLA. So that could help and improve recruiting. Bad thing, I hate to say it, but it is possible some managers might be a little more inclined to discriminate against pregnant employees that they or candidates they're interviewing. So I think that's a good opportunity for some manager training so that they're not doing that, whether intentionally or implicitly. But just something that to have in mind. Another thing is, this is an entitlement of 12 weeks. It is concurrent with FMLA if the FMLA is for the same reason, but it is not concurrent if the FMLA is for a different reason. So you are having a child, you have your 12 weeks for bonding, but you then also have another family medical leave situation. The employer is entitled to take both of those. Within the same calendar year, it can only add up to 20 weeks, but intermittent leave is limited to 480 hours for the whole 12 weeks. And I'm going to slyly glance at Anabel to make sure I got that right. I did. Okay. And so, yeah, there's a lot of numbers here. Just want to make sure. So those are some fairly big changes to the amount of leave. I think that one will be pretty meaningful. Minnesota also has lactation accommodations and more break times, reasonable times. Those are on the slides. One thing to note here, you can't require the employee to line up their pumping breaks with breaks already in place. It has to be on that employee's schedule. And the federal one lasts for 1 year. There's no limit on the Minnesota time. So that goes on as long as the nursing parent decides. So here also, this should go in your handbook. Has to be given out as at time of hire. If you've hired people but haven't updated your handbook now, just give them the new handbook, sign off on it. It's a new law. You're doing it as fast as you can. I don't foresee that being a huge issue for now, but it just needs to happen. We have educate employees on what's happening. And another thing you might want to educate your managers on in addition is when to refer employees to HR is, I think you can probably educate them on when they don't need to come to HR, right? Like if someone needs to go get a glass of water, let them. They need to go to the bathroom, let them. You're all very busy. I don't think you need to know every time someone needs to use the restroom. So just, I'm a recovery. I was in HR before I went to law school, so I'm thinking these things through. So I think you can educate and give managers some empowerment there. And I think then I turn it back to Rebecca.
Yeah. So another federal Supreme Court decision recently was Groff v. DeJoy, and this expanded religious accommodations under Title VII. And so generally speaking, Title VII requires employers, as it says on the slide, reasonably accommodate religious practices unless there's an undue hardship. And up to this point of this case, that has been interpreted both by EEOC guidance and by prior case law as being more than a de minimis cost, but it was generally interpreted as a standard that was lower than, for example, the undue hardship analysis under the Americans with Disabilities Act. Now, we thought about this a lot during the COVID pandemic because there were myriad cases being brought with regard to religious exemptions for getting the vaccine. And we thought that this might be a ripe environment for the Supreme Court reconsidering the religious accommodation standard in the midst of the pandemic. Interestingly enough, this case does not involve COVID and it does not involve vaccines. This is a Christian worker, Mr. Groff, sued the United States Postal Service for failing to accommodate his practice that he did not want to work on Sundays. Whether I have 2 slides or 1 slide. Yeah. So the folks on Mr. Groff's side of the arguments really pushed for a standard that was similar to the ADA. They wanted to say these should be the same standard. The Supreme Court did not go that far. But they did go further than what we understood the standard was up to this point. And so they basically said, you should be looking at this as whether we should be looking at it from the point of view of what is the burden on the operations and the employer side of it, and substantial increased costs, as opposed to what I think people used to do, which was kind of in sort of look at the practice and whether there was a way around what the person was asking for, right? So you're really going to be accepting the person's statement about what the religious accommodation is, and then you're going to look at whether or not that causes substantial increased cost and on your particular business. That's the quote. But what that really does is makes it an individual fact-based inquiry like the ADA. It's just that costs is really more explicitly a factor, the way they often say cost is not a factor under the ADA. So that's sort of the takeaway. So we expect there to be more accommodations that are granted in the wake of this, though perhaps not the floodgate that we feared. For those of us who don't want to be granting all these accommodations. Again, I mentioned this earlier already, but basically there was an opportunity to adopt just the ADA. So we'd have one standard, right? And we'd have one standard, but we now have two standards. The one standard that we're used to is now a little higher of a burden, but it's not as high as the ADA. So we're still learning two standards. And then the idea is, again, to look at sort of the impact on your operations and the cost to accommodate, not on what other employees might think, which is true under the ADA too, and not sort of on what you might think of the religious accommodation. So focus on, could there have been a way to never schedule Mr. Groff on Sundays, was really the analysis that the court wanted the Postal Service to make. Could they have never scheduled him on Sundays? Right? Could they have worked around that? Now, of course, they have thousands of employees. So the idea was there's probably a way to not have one person work on a Sunday with thousands of employees. So that analysis might have been different in a 5-person, well, that's a bad example, in 30-person, because it wouldn't, instead of 7, 1, and 5, you're gonna have 30 people. So in a 30-person workplace, that would be a different analysis. Okay. So I think that's the end of our formal explanation of the laws as we know it.
Sounds great.
So now Anabel's going to quiz us.
This is
The same
This is
panel.
the fun part. So yeah, we've got a little bit of time left. Let's see how many questions we can get through. So let's start with the topic that seems to be causing folks a lot of angst. Minnesota's paid family and medical leave law. For starters, Rebecca, do you foresee this new law imposing significant financial burdens on employers? And along that note, is there an exemption for small businesses?
Yeah, I'm going to take the second one first if I can, because that's a little more straightforward.
Mhm.
So there is some relief for small employers, and that would be defined as employers with fewer than 30 employees. They're going to be paying a reduced tax, so it's that contribution tax, and the fund will absorb the gap in terms of letting any employee who works for that small employer still get the full benefits. Now, the employee tax is the same no matter where you work, or at least proposed to be the same. But the employer tax will be smaller. There's also money allocated, so this was a somewhat funded mandate in the beginnings. There's going to be some sort of fund to help small businesses pay for temporary staff if you have to deal with folks who are on leave, and so you might have to avail yourself of temporary staff while those folks are on leave. The program, generally speaking, is going to be 0.7% is going to be the payroll tax, and that's split equally if you're a large employer, 0.35% for each. So is 0.35% payroll tax a significant burden on employers? that's for the employers to, to sort of, decide in that regard. I think it's gonna be an administrative burden, and that might require more HR staff. So that in and of itself could, be difficult for employers to, get, to administer. And I think it's gonna be complicated for really large employers who have to manage this in many different states with slightly different rules in each of those states. But in that way, it's no different than many of the other laws that we've all been talking about thus far.
Like having different unemployment accounts in every different state, right?
Exactly,
That's, yeah,
exactly. Or different paid sick leave that's
Right.
required or something like that. Yep, exactly.
So for your clients that are in states where paid family medical leave has, recently been enacted, what are they telling you? Has it been harder than they anticipated it would be, or what has their experience been?
Yeah, so putting aside the philosophical objections that I get to hear. It is mostly an administrative burden on the states because it is administered through the State Department. So that's
Okay.
mostly what I'm only aware of one of the clients that I work with regularly who has kind of applied in all the states that they are in for an exemption because they have a private fund. So to them, they had a robust benefit plan. They're very large. And so they just kept doing business as usual and basically that we've got a plan. So exempt us from this. And that's kind of how they dealt with it. I had another client who was contemplating that with one of the ones that's about to come into play, and then sort of got midway through. I think I said this, and they decided, you know what? It's really not worth the point. It was a little slightly under 0.35%, but it wasn't worth the 0.35% savings to do what the state was requiring us to do annually to stay exempt from this process. And so they decided to keep what they have as a self-funded kind of paid time off policy, not quite unlimited PTO because they've listened to us and all of the woes about that, but pretty generous. And so what's interesting is that in one of the states that they're in already, that kind of operates the same way severance. And I don't know if Minnesota is going to work this way, but that kind of operates the same way severance does, right? If you pay an employee severance, they're still unemployed and they can go to the unemployment department, but the unemployment department is not going to start giving them benefits until the severance runs out. So paid family medical leave theoretically is for people who aren't being paid while they're on leave. So if they're being paid while on leave, there's going to have to be some double dipping kind of offset there. So I think that the clients that have experience in other states are finding that it isn't any more difficult than monitoring their severance practices and plans against state unemployment. Now, I don't know whether that's going to work that way in Minnesota because they do have a complicated process, at least that they articulated in the kind of not directly in the statute, but in the materials we got for that.
Got it. And so so obviously employers have been navigating the federal FMLA since it was enacted in the 90s. And I guess this is for either of you, Jillian or Rebecca, in your opinion, would you say Minnesota's paid family medical leave is more generous, a little bit more limited? Is it some of both? Like, how do those differ?
I'm gonna ring the bell for Minnesota being more generous. Well, first of all, you've got the P, right?
Right.
That's a big one, because I mean, the truth is, for many people, 12 weeks of unpaid leave is meaningless because they can't afford to take it. So it's a game changer in that way. So that's huge. The expanded family member definition is big as well. Rebecca and Anabel both touched on those, but I think, it reflects not everybody has the typical Norman Rockwell nuclear family. There's lots of structures of people who care for one another. So it expands that. And then there is the fact that you can have the 12 weeks of the paid family medical leave for pregnancy, and then the additional leave for other qualifying conditions, totaling 12 weeks. There is the one thing where it's 7 days of incapacity versus 3 days of incapacity for some types of FMLA qualification as a serious health condition, but it's minor, it's one subset. I mean, chronic health conditions are a big piece of FMLA, so I'm gonna come down on Minnesota. Rebecca, I don't know.
I would too. I mean, and even just, let's not even put the P on the table, but that is an obvious big weight. I think you're right. I think the expansive definition on the family part of the FMLA
Right.
is huge. I think that's really, really huge. I also think that the paid, even I just was gonna put away, I think you really brought up a really good point. I think a lot of people don't take their full FMLA. That probably doesn't feel true to you. I'm sure you think everybody takes their FMLA and how the heck do I manage it? More people are gonna take it now that it's paid because it will be less prohibitive. So I think that's a big game changer for you all, even if it's being mostly paid by the state. And not by you. I think it's gonna cause more absences. And so I think that's a big thing for folks to consider. But I also think that expansive definition, and I agree with you, I don't think the 7 makes it less beneficial, because I think almost everybody who met the 3 days under FMLA was really meeting the 7 days too.
Yeah, and I think to some regard, you can plan for it. I mean, it's likely gonna be your lower paying positions for whom the paid part will be the game changer. The higher paying positions are less likely to have been unable to take the leave because of financial reasons. So you can kind of see where that might create a difference and plan accordingly.
And so for clients that have offices in multiple states, they're navigating, you know, this patchwork of laws, given more and more states and cities are passing paid family medical leave. So Rebecca, you know, how are your national clients dealing with this?
So I think,
Some
yeah.
tips for
Yeah.
folks in the
I think it
audience.
varies by the industry. And I think you kind of hit on it with the prevalence of sort of lower wage workers and the sort of volume of those within your workplace as compared to sort of higher end professional workplaces. I think it also matters as to whether you're what's your sort of overall employee relations compensation philosophy. Are you I'm happy to report that Dorsey thinks of itself as top of the market in compensation. So you know, they want to take that off the table when they're recruiting talent, right? And many other employers are like that. So if that's your compensation philosophy, then you might want to jump ahead of what the law is requiring, right? And so you might say, we've got really generous paid leave benefits anyway, right? And so many clients are doing that. Many clients are like, no, we're mid-market. That is not a factor in that. We're happy to compete with other mid-market people. Then managing closer to these entitlements is going to be a factor. And I think that, you know, that ROI kind of concept needs to like come into play. Like how many more HR staff people and payroll processors and bells and whistles on your payroll service provider that's web-based do you need to pay for in order to minimally comply with arguably 50 different laws? And that's a big factor with many clients. It's a little like the shoplifting factor, right? Like nobody cares if you take that thing of gum, right? They clearly aren't monitoring that, but all the leather coats have, you know, locks on them, right? Somebody's done an analysis in the store. The gum can go, but that coat stay in here, right? And in a way, you have to think about all of this stuff now in that same bucket.
Right. Do we have time for one more question?
Sure. Go ahead.
So Jillian, with regard to, you know, pregnancy related accommodations, let's say a client has an employee in assembly line that works in assembly line and they're in Minnesota and they need to pump every hour. What is the employer required to do in that situation or in analogous situations?
Let them pump every hour. It's clear under both statutes. In Minnesota, there was an exception for whether it would, quote, unduly interrupt the employer's operations. That's been revoked. And under the Pump Act must provide reasonable time for each person needs to pump. And, you know, sometimes people abuse things, not most people, but occasionally. And I'm already thinking, all right, what's gonna be asked? Like, somebody thinks they're not actually pumping during those breaks. What are we gonna do? How are we gonna monitor this? But, I think you'll have to see if you see it, how that plays out in your workplace and the type of work. There's a lot of variables on how hard that's going to be to comply with. But the answer is unequivocally, you have to let them. Right, Annabelle?
I would agree, yeah.
The federal is you must provide reasonable time each time the person needs to pump. So I suppose you could tinker with what's reasonable, but not the frequency is my read on that. And these are all new. There, will be case law eventually, but for now, that's what we're seeing.
All right, panel, thank you.